Welcome to the Lawyerist Podcast with Sam Glover and Aaron Street. Each week, Lawyerist brings you advice and interviews to help you build a more successful law practice in today's challenging and constantly changing legal market. And now, here are Sam and Aaron.
Hi, I'm Sam Glover.
And I'm Aaron Street, and this is episode 151 of the Lawyerist Podcast, part of the Legal Talk Network. Today we're talking with Alan Sugarman, whose HyperLaw service in the early 1990s paved the way for modern research services like Google Scholar and Fastcase.
Today's podcast is sponsored by Ruby Receptionists and its smart, charming receptionists who are perfect for small firms. Visit callruby.com/lawyerist to get a risk-free trial with Ruby.
Today's podcast is also sponsored by Clio Legal Practice Management Software. Clio makes running your law firm easier. Try it for free today at Clio.com. So I guess today's episode with Alan Sugarman is kind of one in our ongoing series on how we got to this place where open access to law is a conversation. We've had a number of these interviews with Tim Stanley and Ed Walters and Sarah Glassmeyer. I think this will be an interesting story as a piece of that.
Yeah, I kind of geek out on the nuts and bolts of how we get to where we are today. And one of the reasons why I'm interested in open access to law is that law is kind of the oil, Ed Walters would say, on which innovation in a lot of legal tech works, right? Like if you want to build AI, you have to have a data set to train it on. And a lot of that comes from open access to law. You can't have it unless it's open. So that's why I've been doing some of these interviews, because I think it's fascinating. But I think what you will also hear as an undercurrent in some of these interviews, it was there with Tim Stanley and with Carl Malamud, and it's here in my interview with Alan Sugarman, is that some of today's competitive landscape is due to a series of incidents that have resulted in grudges that weren't always pretty. And I think you'll hear that today. I think you've probably heard that in some of the previous ones. But the lawsuit over HyperLaw and the history of it and background and what happened is pretty interesting. So here's my interview with Alan. Just another note, my audio, again, isn't great for the first few minutes this week, but then it clears up. And please be reassured that I've upgraded my recording gear at home, so snow days won't muck up my interviews so much anymore.
Oh, good.
Here we go.
Hello, I'm Alan Sugarman. I am an attorney in New York City. I've been practicing since 1971, and I'm the founder of HyperLaw, which in modern day terms was the disruptor of the legal publishing industry. And we took on the monopolist West Publishing and we beat them. And that was in 1997 and 1998.
Awesome. Thanks for being with us today, Alan. Maybe before we dive into the litigation, which I really want to talk about, what was the lay of the land before HyperLaw came along in 1991? What did legal research look like back then?
Well, legal research back then was still largely paper-based, and people used books, and people used the key numbering system to do their research. Lexis had been founded in the 70s, and West Publishing Company, which people call today Westlaw, created its online service a few years later. It was the federal government that had really initiated legal research online, or digital legal research. It was done by the Air Force. Flight was an effort by the U.S. Air Force to digitize U.S. Supreme Court decisions. And it was made available to lawyers in the U.S. government. And then that evolved into something called Juris, which the Department of Justice worked on, and they were digitizing legal opinions, federal opinions, starting in the 80s. And then they got West Publishing Company to help them do the digitizing and gave West an exclusive contract and made it clear that those cases weren't subject to FOIA requests. And so there was litigation where people were trying to get their hands on Juris. And then the big thing that happened was in the mid-'80s, Lexis decided it was going to start using the so-called star pagination that West had developed, the cite to the page, the volume and page number of the cases. So West jumped on them, and following something they did for almost 10 years after that, they, of course, sued them in Minnesota. in the federal courts where they'd been cultivating judges for years, and where the cases would be reviewed in the Eighth Circuit where they'd been cultivating judges. So West jumped on Lexis, which was owned by Mead. And by the way, Lexis was originally a product of the Ohio State Bar. And West was able to get an injunction against Mead, claiming they had copyrights and the text, the enhanced text and the citations, and won in the Eighth Circuit, which wasn't a surprise given some of the things that had gone on, including the Devitt Award, which was basically paying off federal judges with awards and trips to resorts.
I mean, that sounds pretty cutthroat. We don't normally think of legal research as a cutthroat industry, but.
Oh, no. West was incredibly litigious. They were suing people right and left. And at this point in time, the cost of converting paper opinions to text was pretty expensive. This was way before optical character recognition.
Yeah.
And even in the 90s, OCR, as we call it, was not so robust. And so the way they had to do it was have it keyed in. And even the facilities to keying in, basically in India, were not as developed as they are today. So it was a big expense just to get a court case converted digitally. And of course, at that time, even though there were some word processors around, judges were, I would say 95% of all opinions were being typed on electric typewriters or handwritten. So there was no way of getting digital versions from the court. And if they were digital versions, they were in specialized publishing, printing software.
I mean, that kind of puts it in perspective, because like when I talk to Ed Walters, I'm appalled by how much effort they put in to maintain legal decisions coming into Fastcase's database. But by contrast, the amount of effort that you had to put in to do that back in the 80s and 90s sounds like it was just crazy higher effort. So.
Well, it was even worse than that. I think West didn't even bother, even once word process decisions were available in word processing. It wasn't worth the time to try to convert the digital word processing files. There were so many different programs, the ways that people did it, and formatting and everything else. It was just, at the end of the day, easier for them to send it to India or somewhere else and get it double keyed and bring it back to the U.S. So they just ignored that. So in a minute, I'll get to what we did.
Well, I want to hear about that too. So
okay, so West v. Mead basically gave a monopoly to West over the content and the citation to the content of judicial opinions. And so our involvement was that I had been very involved with computers and the law for years. In fact, in the early 80s, I'd even taught a course in computer literacy for lawyers in 1982. My original computer had 4K of memory. People know what that means.
Yeah.
So I was pretty involved with this. When I came off my big case in 1990, I finished up a real estate book and decided that I wanted to do an electronic version. I reserved the rights with my publisher, John Wiley, who didn't know what I meant when I said I wanted to do an electronic version. And I wanted to link into the cases. So my question is, where do I find the cases? This was all going to be on floppy disk, if you can believe it, and then CD-ROM. So I wrote a letter to West saying, look, I know the only place I can find these decisions is from you. From my litigation experience, I'd spent too much time wandering around court clerks' offices and dusty boxes trying to find old files. And so I wrote them, and they said no. And they basically said, quote, said, proceed at your own risk. And I knew they'd been after other people, and they were starting to take the position that if you did a brief with links to cases, that you had to get their permission. If you went to a law library and wanted to photocopy a case, they wouldn't do it unless basically they paid a fee to West.
Wow, really?
Oh, yeah.
That's crazy.
No, absolutely true. Absolutely. So West wanted to control everything. And Now, this was 1991, before the internet, but I had realized that digital linking to briefs, for example, or treatises would be the way of the future for the development of law. It wasn't so much legal research, but it was the ability to present the case to the reader without having to go do legal research. And I realized this would thwart the whole development of law. I was offended by it. And I'd read an article about hyperlinking by Vannevar Bush, which he predicted this back in the 40s. And so I created Hyperlaw to do my book. And then I decided that maybe the first thing to do to test West and also to perhaps create a future product would be to start publishing the text of the U.S. Supreme Court. Now, at that time, they had a very elaborate, funky system for making cases available to newspapers and publishers. And you had to sign up and go through all the security stuff. And there were maybe 10 to 20 publishers in the country who did this. But we managed to sign up, buy thousands of dollars of secure hardware. I mean, we were just accepting a download, but I think in their mind, if we get a download from them, we can mess up their system. So we got their decisions, we got them all formatted, cleaned up, found a search engine that would fit on a floppy disk and a CD-ROM, released it. And the idea I had was perhaps to do reviews of Supreme Court cases or something like that. And so you could buy every year, I never did this, but buy every year a review of the Supreme Court cases for the year, and you can link into all the cases. So that was the idea.
It sounds like Hyperlaw was basically like Microsoft Encarta, where both the software and all the data is on the CD that you would buy.
Yeah, that was the idea.
Yeah. Huh.
And so we then released the CD at Legal Tech in New York in 1992. We were the only company with any CD product. We were told the CD was a dead technology, but I would tell you the West people went hovering around my booth. We didn't sell very many. It was not a commercial success. I then discovered that some of the Court of Appeals were starting to release the Federal Court of Appeals opinions on their bulletin boards. And so I decided I would download as many as I could and put those on a CD. And that turned into an elaborate product. I had 2 or 3 interns from Columbia Law School, one who was a good programmer, and I did my own programming, and it was a huge problem of downloading cases, just figuring out if you had duplicates, cleaning them up. Each one was in a different format. But we put together a pretty nice case which had metadata in it. We used, pretty intelligent searching to create the metadata. Mm-hmm. And we had a real product. And then we went to the American Association of Law Libraries Convention in 1993 in Boston, which is really big. It was a big event in legal publishing. Mm-hmm. And Wes, again, came hovering around my booth, and I mentioned that, well, we don't have all the cases. And they said, well, you better not use our cases. Well, I took that as a threat. Then what happened in 1994, Matthew Bender, which was an independent company then, was trying to publish treatises of New York case law. And they needed the cases. They wanted to do the same thing I had in mind. I'm not claiming to be original in any way, because it was obvious that was what people wanted to have. They were running into problems, but they wanted to use the citations to the cases, the volume and page number.
Whereas you were just using the cases themselves.
Well, we were downloading the cases, which had nothing to do with West, but what we wanted to do was fill in the gaps with the cases that weren't being downloaded, because the courts weren't so complete. Anyway, Matthew Bender sued West in New York City, where we're located, in the Southern District of New York, where I was admitted to practice law and had practiced, and sued them for declaratory judgment. And when I saw that, this was early 94, I said, oh no, we're going to have another fix where 2 big companies sue each other, and then after they beat each other and the lawyers collect their legal fees, they enter into a private settlement, and everyone else will be screwed. So 4 weeks later, we intervened. and have a very long, detailed complaint that we filed. And my friends Paul Ruskin and Carl Hartman agreed to basically be pro bono lawyers with the hope of getting legal fees at the end. And they put an awful lot of work into it. And we were allowed to intervene, and we pursued the case. And I won't go into all the details, but
was the core of it, though, was it a fight over the citation system then, or?
In the beginning, Matthew Bender seemed to be interested in both, but I always was interested in the text part. In fact, I've left this out of my story, but after West v. Meade, the Supreme Court came down with the Feist case, which totally undermined the theories in the West v. Meade case. And then Meade and Lawyers Cooperative got Barney Frank to introduce some legislation in 1992 in Congress, H.R. 5522, and to make the citations not copyrightable. And we went down to Washington and we filed our brief where we said, well, that's fine, but we also want to make the text not copyrightable, because West would claim if it corrected parallel citations, corrected typos, added the attorneys' names, that they were entitled to copyright protection for that. And if you picked up a West case, you didn't know what they were asserting copyright for or not. Mm-hmm. It was very interesting then that no one else in the legal publishing industry would support our position on text. Okay, so when we got into the Matthew Bender case, Matthew Bender, I think, initially was going to fight for both text and the citation system. And then they were acquired by Meade Data. And Meade had so much money invested in its own conversion to text that they did not want us to take that position. In fact, they even fought us at the end when we got before the Supreme Court. They wanted the Supreme Court to overturn our win. So what happened?
Effectively what you have happening is two people with essentially identical reporters are saying that they each have different copyrights in their own version of it.
Well, it wasn't so much, they didn't want people going on Lexis and downloading the text of cases and saying you can't copyright it. Mm-hmm. And they didn't want to depend upon a contract in your contract with Lexis to keep you from copying it.
Right.
Okay, so we both won the citation case. And then Matthew Bender sort of disappeared, and we alone won the text case. And as far as I'm concerned, the text case is much more important than the citation.
Yeah.
And we won in the Second Circuit. Cert was denied by the U.S. Supreme Court. We came back to get legal fees. The judge said we were David and Goliath and won the case, awarded us fees. The Second Circuit said, no, you're not substantial. There was a substantial issue, and which was really ridiculous. And because no one ever supported the Meade case. There you are. So we were sitting there in 1997, 98. The last legal fees decision was 2000 or 2001. So that's what happened in that case. But basically, our case made Google Scholar, Google Law, possible.
Right, because the outcome is now you can, obviously you can publish the text of cases and you can use the citation system, right? Or is the citation system still in doubt?
No, there's no doubt on the citation system. And initially, oddly, Google did not include the citations. Mm-hmm. And I would write them. I never really talked to anyone senior there, but I would say, why aren't you putting the citation in? And now they have the citation in there, the pagination for the published opinions.
So we need to take a quick break to hear from our sponsors, and when we come back, I want to talk about what happened to HyperLaw after that, and maybe spend a little time talking about the impact of that decision, that ordeal, that litigation today, and what maybe still needs to happen to keep the law free. So we'll be back in a moment. This podcast is supported by Ruby Receptionists. As a matter of fact, Ruby answers our phones at Lawyerist, and my firm was a paying Ruby customer before that. Here's what I love about Ruby. When I'm in the middle of something, I hate to be interrupted, so when the phone rings, it annoys me, and that often carries over into the conversation I have after I pick up the phone, which is why I'm better off not answering my own phone. Instead, Ruby answers the phone, and if the person on the other end asks for me, a friendly, cheerful receptionist from Ruby calls me and asks if I want them to put the call through. It's a buffer that gives me a minute to let go of my annoyance and be a better human being during the call. If you want to be a better human being on the phone, give Ruby a try. Go to callruby.com/lawyerist to sign up, and Ruby will waive the $95 setup fee. If you aren't happy with Ruby for any reason, you can get your money back during your first 3 weeks. I'm pretty sure you'll stick around, but since there is no risk, you might as well try.
Imagine what you could do with an extra 8 hours per week. You could invest in marketing your firm, you could spend more time helping clients in need, or you could catch your daughter's soccer game. That's how much time legal professionals save with Clio, the world's leading practice management software. With Clio, tracking time, billing, and matter management are fast and easy, giving you more time to focus on what really matters. And Clio is a complete practice management platform with plenty of tools and over 50 integrations to help you automate daily tasks such as document generation and court calendaring. See how the right software can make it easier to manage your practice. Try Clio for free today at Clio.com.
So, Alan, after the decision, what happened to Hyperlaw? I mean, it's not on the market today as far as I know. So were you able to take that and run with it, or what happened?
In 94, 5, and 6, we were litigating against the largest law firms in the country. We actually went through 3 law firms that West had. And in the end, they had to have Arthur Miller from Harvard Law School come down and argue for them in the Second Circuit. Just doing the case was overwhelming me. And by the time 1998 came around, I'd run through all my money. So I had to go back into the real world and make a living.
Yeah.
So Hyperlaw still exists. I comment on things from time to time, do some litigation support. But we, at least in the Second Circuit, we have this absolute right. There's no way West can touch us in the Second Circuit. They can't play that game. During this whole period of time, there were other fights going on involving the vendor-neutral citation, PACER. We were very active in testifying before the ABA committees on this, the Judicial Conference. We worked with the American Association of Law Libraries. And I want to give a real heads up to Jamie Love for the Taxpayer Assets Project, who was extremely supportive. That's a NATO group. He got involved in 95, and he was one. We worked with him a lot. We were all over the country, and one of the big issues had to do with the vendor-neutral citation, which even today I don't understand what's going on. But let me explain something about the vendor-neutral citation.
Yeah.
Our position was that vendor-neutral citation had to be one that could be immediately citable. The day the opinion came down, you could cite to that opinion and use that citation forever and ever. And how do you do that? You have the name of the court, the date, and the docket number. And there you are. You have a permanent cite. The other people involved in this got all involved with this idea where the courts have to control what you can publish and not publish, and you should have a sequence number, et cetera, et cetera, et cetera.
Well, and the citation thing is even though you can use West's or Lexis's citations, they still control the citation. You know, what you're effectively waiting for is them to put it in a book and give it a page number, which is, I'm not even sure if that's even a real thing anymore. I'm sure they still publish books, but they're not super relevant to anyone. But you're still waiting on them to decide what the citation is, which is hard, especially since nobody actually cares if it's in a book anymore.
Absolutely, Sam. And I think, first of all, you're talking just about the published opinions. There are also unpublished opinions. And most people actively use unpublished opinions. And there's a lot of courts say you can't cite a case that's not been published in a book. But that's evaporating day by day.
Well, it's also really torturing the meaning of published when everything is being published. It's just a technicality.
It is, although I always said judges did not want their bad decisions or embarrassing decisions to be published. And West controlled what was published. West did not publish our victories in the text case. There's a full written decision, and they didn't put it in the federal supplement. I wonder why. But let me go back to what you were saying, since you've really practiced law. Have you ever gotten a Lexis cite to a case that was never published, but you only use Westlaw?
Right.
And then you go try to find it in Westlaw, and you can't find it because there's a lot of discretion in how you name a case.
Yep.
And you spend hours trying to find it. And that's just extraordinary that can happen today. I believe today that all cites to all court opinions should have the docket number of the case in it.
Mm-hmm.
And for unpublished opinions, a lot of courts are disseminating them, and they're available on all the various services. If you have the docket number and someone cites a Lexis site and includes the docket number, you wouldn't have to go and pay money to West or Lexis to go find the case.
Right.
And I can tell you, just 3 weeks ago, I got a brief in a case, and he cites 3 different Lexis cases from a New York lower court. And even with the name of the case and going to the court system, I couldn't find the cases, even though they're somewhere in their electronic system. And there's another reason to use the docket number, and that is the docket number allows you to link the lower court opinion to the appellate opinion. All appellate opinions should list the docket number of the case below. If you go into Google Scholar now, they have a problem of linking an unpublished lower court, district court opinion to an appellate court opinion, the federal appellate court.
Right, but that should be a piece of cake.
If they included the docket number in both.
Mm-hmm.
But all of these groups, including the American Association of Law Libraries, GPO, RECAP, Google Scholar, and the Legal Information Institute citation system, none of them require the docket number in the citation even of an unpublished decision. I have been very explicit with them about this, and it just doesn't happen. Tim Stanley at Juris goes better. He includes the docket number, and he also includes the more specific site, which is the docket entry number on the docket sheet for the federal opinions that he publishes. That is a beautiful site. I'm just waiting for them to wake up to this. I've been fighting this for 10 years. People look at me like I don't know what I'm talking about, and eventually we'll get there.
Yeah. I mean, the Hyperlaw decision really, the litigation really paved the way for what we have today, which is you really do have choice. Like in at least some surveys, services like Fastcase are neck and neck with Westlaw and LexisNexis, which is kind of amazing at this point. And you've got all kinds of other secondary services. Bloomberg, is charging hard to catch up with everyone, and so is, I think it's Casemaker, and there's a bunch of them out there now. And I think none of this would have existed if Bender and then you hadn't dived into this litigation.
Well, Google Scholar is the beautiful.
And Google, yes, of course.
Okay, I frankly, even when I was using Lexis, which I stopped using, but I would always start my research in Google Scholar.
Yeah.
It's faster, quicker, more informative, and also reaches outside of the case network to find more information. I give them really great credit for what they've done, and they've pushed the whole field. For everybody else is doing this kind of stuff is basically trailing behind in their footprints.
Mm-hmm.
I mean, at the same time that certain people were paying allegedly $600,000 to digitize the Federal Reporter, Google was doing it at the same time.
Yeah.
And of course, I'm not from California, so there's almost a mafia out there. I'm not really sure what goes on out there, but I had always assumed that Google was paying for this, but I don't know. I don't know the whole thing. People claim they paid for it. And then when they were finished, they said, we now have all federal court opinions available for nothing. And I said to them, that's not true. I said 90% of the federal appellate court opinions are unpublished opinions. You don't have any of those.
Yeah. So what can the average lawyer do to support the move towards neutral citations?
Well, the first thing they ought to do when they write briefs is to start adding the docket number of cases that only have Westlaw or Lexis sites or that are unpublished. They should put that in every single site so that judges who, by the way, today a lot of judges are pretty sophisticated in this, but just to get people used to seeing that.
I mean, I feel like a small act of rebellion would be for all of us to use vendor neutral citations first and then put the Westlaw or Lexis citations in a footnote or something.
I would not include the Lexis or Westlaw site. In fact, I don't. I put in the docket number because if you have the docket number, the name of the court, you can find the opinion in Lexis or Westlaw quickly. because docket number is one of their metadata fields that you can search
Well,
on.
and in many courts, you can link directly to the court in the docket anyway. So,
Right.
Well, Alan, thank you for your work and for telling us about it. Thanks for being the one to stand up and do this, because it has at least opened the door to a much more robust market for legal research options.
I'm glad that it has come to fruition. And again, I thank Google Scholar for what they have done, which has taken full use of what we accomplished in 1997.
Well, maybe in another 20 years, we can get back together and see if vendor-neutral citation has finally come around.
I hope so.
I'll see you then.
Sam, nice talking to you.
You too.
Bye-bye.
Make sure to catch next week's episode of the Lawyerist podcast by subscribing to the show in your favorite podcast app. And please leave a rating to help other people find our show. You can find the notes for today's episode on lawyerist.com/podcast.
The views expressed by the participants are their own and are not endorsed by Legal Talk Network. Nothing said in this podcast is legal advice for you.